Okay, calling to order the Joint Committee on Ways and Means and Judiciary. So this afternoon we'll hear from the Judiciary and Department of Attorney General, who will present their biennial budget requests. So we'll begin with the Judiciary. Good afternoon.
Good afternoon, Chair De La Cruz and WAM committee members, Chair Rhodes, Vice Chair Gabbard, and Senate Judiciary Committee members. I'm Tom Mick, Head of the Judiciary Policy and Planning Department. With me today are the Administrative Director and Deputy Administrative Director of the Courts, Rod Miley and Brandon Murray, and other key judiciary personnel. Would you like me to introduce them all? Or?
Okay. I mean, they came.
It might take all afternoon. Okay. Let's go down the line. Michelle Acosta, Deputy Chief Court Administrator, First Circuit. Johanna Choktam, Olelo, Hawaii Program Administrator. Harry Gearan, Financial Services Department Director. Susan Gokros, Intergovernmental and Community Relations Director. Erin Harbinson, Criminal Justice Research Institute Director. Jan Kagahiro, Judiciary Communications Special Assistant, Intergovernmental Community Relations Department. Joanne Crepane, Capital Improvements Program Administrator. Roland Lee, Office of the Public Guardian. P.D. Letts, Deputy Chief Court Administrator, First Circuit. Jasmine Malmakai, Children's Justice Center Statewide Director. Mai Nguyen Van, Information Technology and Systems Department, Acting Director. Laurie Akita, Chief Court Administrator, First Circuit. Becky Sugawa, Center for Alternative Dispute Resolution. Karen Takahashi, Legislative Coordinating Office. Eric Tanagawa, Human Resources Director. And Gary Taramai, Policy and Planning Department, Budget and Statistics Director. Thank you for the opportunity to present an overview of the Judiciary's biennium budget and its related requests, its mission and functions, the effects of COVID and the economy on the judiciary, and how the judiciary has responded to move forward through all this. I have a PowerPoint type presentation I think has been uploaded on your laptops that ties in and tracks with my presentation today. Or if you are uncomfortable with that, I have hard copies if anybody needs a hard copy that I can give them. Sure, I'll take that. As I think most of you are aware, the judiciary's primary mission is to adjudicate disputes brought before the courts and administer justice impartially, efficiently, and in an accessible manner in accordance with the law. However, that being said, the judiciary, like other judiciaries across the country, has been evolving and moving away from simply administering justice and adjudicating disputes towards being more focused on treating individuals and the causes of their problems, on trying to avoid incarceration and the cause and all that goes with that, and most importantly, improving access to civil and criminal justice systems. With the onset of COVID and the pandemic in 2020 and the resultant adverse impact on business activity, tourism, and the economy, the legislature took action to reduce overall expenditures and balance the budget. The judiciary's share of this action was a $9 million budget reduction in fiscal year 20 and a $14.7 million budget reduction in fiscal year 21, which included eliminating or defunding the annual salaries of 192 vacant full-time positions including 12 full-time and 8 per diem judges. These actions led to significant expenditure reductions in such areas as POS contracts, jury costs, guardian ad litem and legal counsel fees, and repair and maintenance. For the subsequent biennium, fiscal biennium, that is fiscal years 22 and 23, many uncertainties still existed regarding COVID, the economy, the state budget situation, and the availability of federal stimulus funding. Accordingly, the judiciary submitted no new budget requests for fiscal year 22, and only 4 requests totaling $960,000 for fiscal year 23, which was just 0.6% of the judiciary's budget at that time. We are very appreciative that the legislature made no further budget reductions, honored our requests, and provided significant additional funding to the judiciary either through separate bills or add-ons to our budget. These included monies for such things as collective bargaining increases, restoration of funding for domestic violence, POS contracts, civil legal services, guardian ad litem and court-appointed counsel or legal counsel fees, a women's court pilot program, positions and funding for the Criminal Justice Research Institute, and an additional ICA judge and staff. During these 4 COVID years with the various work, budgetary, and fiscal challenges faced, court operations and related judiciary programs were initially disrupted, but then resumed, adapted, transformed, and moved forward, providing the needed and vital services to the public and the community. Court proceedings returned, be it sometimes in person, sometimes remotely, or some sort of hybrid arrangement. Jury trials restarted with appropriate safeguards, and clients could once again be assigned to various treatment or other type programs or specialty courts. Through all this, the judiciary never lost its focus on access to justice and helping self-represented litigants to the maximum extent possible. As you can see from the PowerPoint, one of the PowerPoint slides, this could be in the form of specialty court, such as girls' court or mental health court, or by helping self-represented litigants through such programs as self-help centers or the Volunteer Attorney Pilot Project. I just want to touch on just a few of these. The Community Outreach Court for Residentially Challenged Individuals was initially established for in-person meetings at various rural locations. But because of COVID, transformed into a hybrid model with remote video conferencing also being used. Since its start in 2017, 470 individuals have completed the program. Over 7,600 cases have been cleared and are no longer active. Almost 800 bench warrants have been recalled, and some 5,600 community service hours have been performed by participants. Even more impressive is the number of people served at the judiciary's 6 courthouse self-help centers scattered throughout the state. These self-help centers are staffed by volunteer attorneys who provided 3,000 in-person or phone legal consultations in fiscal year 22, and who have provided nearly 35,000 such consultations since the program began in fiscal year 12. Phone consultations, which began during COVID, became quite attractive because people would not have to take time off from work, find babysitters, arrange transportation, or wait in line to talk to an attorney. A newer program is the Small Claims Online Dispute Resolution Pilot Project, where self-represented litigants can initiate a small claims case, pay or request a filing fee waiver, submit documents to the court, and enter into negotiation or mediation to resolve disputes online. This program was launched just in July 2021, and since then, 900 or 80% of the 1,100 cases that have been electronically submitted have been accepted for retention in the program. I also want to briefly mention two older, well-established programs that are not specifically access to justice, but that provide needed support for children and for medically challenged and generally older adults. The first is the Children's Justice Program and its Children's Justice Centers that are geographically dispersed to meet the needs of children statewide. These centers are facilities where children who may be victims of abuse or witness to crime can be forensically interviewed by professionally trained staff in neutral, child-friendly settings. The mission of the program was just recently expanded to include investigating and managing cases involving child sex trafficking, commercial sexual exploitation of children, and other child maltreatment. In fiscal year 22, over 1,000 child interviews were conducted and 2,000 children were served or tracked. In fact, since fiscal year 11, the Children's Justice Centers have conducted more than 9,200 interviews and served some 16,000 children. The second program I wish to mention is the Office of Public Guardian, which is appointed as public guardian as a last resort for incapacitated adults when friends or family cannot serve or are inappropriate. The professional public guardians at OPG strive to make informed decisions regarding the best interests of the person served and safeguard their rights, their humanity, their dignity, and their quality of life as best they can. The active average client count averages 700 persons, and of which for fiscal year 22, 407 were developmentally disabled. 157 were elderly with dementia or memory loss. 95 had mental illness, and 35 others either had brain injury or other severe health issues. It should also be noted that one OPG accountant has a very large workload in trying to oversee the financial affairs for some 400 of these clients. This now brings us to our fiscal year 24-25 biennium budget request, of which we have 37, for 8 new permanent positions and funding of $7.8 million in fiscal year 24 and $6.9 million in fiscal year 25. These requests center around 5 areas: new facilities, new permanent positions, client services, restoration of funding for defunded positions, and some other miscellaneous but important priority items. Our first set of requests relate to the new Wai'i courthouse that will soon be constructed and is scheduled to open in the spring of 2025, and to the recently opened new and revitalized juvenile services and shelter facility, Hawai'i, located on Alder Street and occupying about 30,000 square feet. For Wai'i, funds are needed to procure position-related furniture, fixtures, and equipment, and to equip the new courthouse with network circuits, phone lines, and other associated telecommunications equipment. For Hawai'i, we are requesting funds for contract security services, for common area maintenance costs, and for janitorial service by restoring funding for 2 defunded positions and a no-cost, temporary to permanent position conversion for another janitorial position. Our next set of requests are for 7 new permanent positions. 4 for a new district court judge and staff in First Circuit, 2 for bailiffs in the Third Circuit, and a no-cost temporary to permanent position conversion for the Children's Justice Center. The new judge would be a part of a pool of judges on a rotational schedule to serve the 4 rural courts on Oahu, and would allow the district court to increase its capacity to serve the rural courts, expand and provide additional court calendars, and provide the flexibility to better manage court dockets and respond to the needs of court users. The additional bailiff positions for Third Circuit, or what we might call tech bailiffs, are being requested to help coordinate and manage the additional duties and requirements to go with setting up, monitoring, and overseeing remote and hybrid hearings. The temporary to permanent no-cost position conversion for the Children's Justice Center is for a forensic interview specialist, a position for which stability is needed, but which has turned over 3 times since 2018 and has been vacant since March 22, since potential candidates do not appear to want to accept what they consider as a temporary position. We also have 3 important client services funding requests related to guardian ad litem legal counsel services, mediation, and mothers on probation children. Last year, the legislature added to our budget $2.3 million for guardian ad litem and legal counsel services, but for 1 year only. That funding was very important to us in that it helped restore such funding cut during COVID, and it allowed us to better compensate and attract more qualified providers and provide children, parents, and guardians with the best representation possible. So we are asking that such funding be continued and added to our budget base. For mediation, the Center for Alternative Dispute Resolution, POS mediation contract, has been at $400,000 since 2009. The contract calls for mediation services for 3,100 cases, but in fiscal year 21, there were 4,420 new cases, and in fiscal year 22, the provider opened 7,154 new cases, more than double the number of mediation services required by the contract. Thus the request for an additional $85,000 for this $450,000 contract. Lastly, the legislature last year gave us $200,000 for 1 year only for residential programs for women on probation that would allow minor children to remain with their mothers while in these residential programs. We believe and we feel that this program ties directly into the 3-year Women's Court pilot program that the legislature provided us with positions and funding last year. And thus are asking for funding to continue this program and also to expand it to such programs as clean and sober housing and therapeutic living. Our 4th set of requests relate to restoring funding for 33.2 positions that were defunded during COVID and are essential and important to the judiciary and to the operations of the specific programs to which they were assigned. For First Circuit, it's 14 positions. One of these positions is a circuit court judge position, the loss of which has resulted in each felony trial court division carrying an additional 33 pretrial cases, as well as picking up 123 hope cases that were held by the vacant judge position. Funding restoration will help alleviate the backlog of jury trials, balance and reduce the caseload per judge, and allow for more efficient case management. Other First Circuit positions for which restoration funding is being requested include a social worker and judicial clerk who address domestic violence matters, 2 social workers that support adult and juvenile community service and restitution, 2 social workers that support drug and mental health courts, a clerk for Hawai'i District Court, an assistant court administrator for Kaneohe District Court, which is the only Oahu rural court without a filled assistant administrator, and a clerk for Land and Tax Appeals Court, where workload has increased significantly from about 3,000 filings, 6,600 cases in fiscal year 19, to 5,800 filings and 11,600 caseload in fiscal year 22. We are also requesting restoration funding for 2 family court clerks that support family court judges, 1 IT support technician to help support the increased use of technology, and 1 accountant to handle the increased workload. For Second Circuit and 7.2 positions, a district court judge, a district court family judge, and a per diem judge are included in the request for restorative funding. The importance of these positions is evidenced by the fact that Second Circuit diverted funds from other vacancies and operational needs to temporarily fill these positions. But this can lead to inadequate staffing elsewhere and delay other court processes. Other Second Circuit positions for which restoration funding is being requested include a branch court administrator in Wailuku with significant and varied responsibilities, a district court clerk in Lahaina, without which various processing delays and other staffing issues have occurred, a judicial clerk on Molokai, which is one of just 2 positions on Molokai, and 2 social worker assistants who provide support for 11 juvenile probation officers and 9 other social workers involved with community service, restitution, guidance, and items. Third Circuit 7 positions for which restoration funding is requested include a janitor supervisor for the Hilo Courthouse and its 7 funded janitorial positions, an account clerk accountant for the Hilo Fiscal Office, a district court clerk for South Kohala that is needed to support court operations and ensure adequate staffing for a court that had a temporary closure during COVID due to understaffing, 3 judicial clerks for Hilo, and a social worker that works in a unit supervising sex offenders. Fifth Circuit has just 2 positions for which we are requesting restoration funding. These are for a court documents clerk, where the 2 remaining clerks have struggled to keep up with workload, and a social worker who is needed to help research and prepare detailed diagnostic reports and make related recommendations prior to individuals being sentenced for their offenses. Lastly, we are requesting restorative funding for 2 Office of Public Guardian social worker positions, 1 on Oahu and 1 on Hawaii, and an account clerk position. The need for funding for these positions cannot be overstated to ensure the welfare, safety, and dignity of each person for which OPG is responsible for, to determine and obtain all the benefits and placements to which these persons are entitled, and to avoid any and all situations which could lead to the homelessness of such individuals. Our last grouping of budget requests are unrelated but necessary. First, funds are needed for justices and judges' salary increases recommended by the 2019 Commission on Salaries and approved by the legislature. Next is the need for monies to replace the judiciary's 4Gov accounting system, which is near the end of its useful life, has become unstable with frequent glitches and breakage, has critical functional deficiencies, and is no longer well supported by the vendor. Lastly, we have been informed by the DAG's risk management program that our share of the risk management cost allocation for the state will increase by $260,000 in fiscal years 24 and 25. While this completes a discussion of our operating requests, CIP or capital improvement program requirements also remain a major item of concern for the judiciary as its facilities age and deteriorate. As shown on the second page of the CIP portion of the PowerPoint that I handed out, the judiciary is requesting CIP funding of $16.2 million for fiscal year 24 for 6 projects.
So members, if you're following, it's our page 69.
Our first request is $775,000 for non-position related furniture, fixture, and equipment for the new Wai'i courthouse, which must be ordered in fiscal year 24 to ensure receipt and installation to meet the scheduled spring 2025 opening date. Secondly, we are requesting $5 million to replace 2 of the 9 elevators in Kahamanu, Hawai'i, which is part of our comprehensive fire alarm and modernization project to ensure the safety of employees and the public and to meet all code and ADA requirements. These elevators are 39 years old, obsolete, break down often, and for which replacement parts are almost impossible to find. Our third request is for $4.15 million for the last phase of replacing the leaking roof at the Kauai courthouse. Replacement is important to remove potential health risks, preserve asset value and extend the life of the building, and provide for easier and more effective inspection, maintenance, and repair. Fourth is the need for $3 million to continue replacement of certain critical air conditioning parts at Leilani Hawai'i, which houses the Supreme Court and is also on the historic register. The rapidly failing air conditioning equipment is some 35 to 45 years old and is contributing to poor air quality, humidity, and mold issues. There are 2 pages on the PowerPoint attached with pictures that show some of the conditions in Asian equipment parts. I think one of the pictures I find most interesting is a fan wheel with no fan blades because the blades have rusted off. Next is a request for $300,000 to plan and design an air conditioning condensate discharge system from Ho'opili, Hawai'i to bring it into compliance with Maui County Code requirements and avoid any possible future permit delays for the building. Our last request is for $3 million in lump sum funding to provide the judiciary with the flexibility to address ongoing and urgent building issues statewide as they arise. This concludes my presentation. Again, thank you for the opportunity to provide you with a briefing today regarding our biennium budget, and we are available to answer any questions you may have.
Members, any questions?
All good. KDC members, any questions? I have some. Okay. With regard to the Office of Public Guardian, the 3 positions that you mentioned as additional requests for this year, $191,000 and $199,000 for the next 2 years. Is that in addition to the 2.3? You're asking for the 2.3 in the second year, right? And then you're asking for an additional 191 and 190.
These are different things. I think Office of Public Guardian.
Oh, I'm confusing.
Yeah.
Guardian ad items, and that's not the same.
Okay. It's nothing to do. 2.3 million was provided last year to us for fiscal year 23, but it was for 1 year only. So we're asking to continue this in our base budget for fiscal years 24 and 25.
Okay. So So with the guardian ad litem's and the court-appointed attorneys at 2.3, you are asking for the second year.
Yeah, both
Okay.
years.
And then can you tell us what the breakdown between the guardian ad litem's versus the court-appointed counsel is?
It was 1.2 versus 1.1.
1.1 for the court-appointed counsel.
Yes.
Okay. And do you have any quantifiable way to report about the impact of the increased funding to meet the needs of persons assigned to GAL for court cases?
Meet the needs
We gave you the money. Is there a metric that we can see how well it worked, what we got from it for us?
Well, I think we can see how much what contracts we put out and what they called for, and I'd have to do that statewide, but we can
Okay,
back you on that.
I'd like to see that.
Okay.
Yeah, okay. So then the budget request is additionally seeking restoration of funding for staff in the Office of Public Guardian. Does that request restore all the OPG funding that was cut during the pandemic?
Well, that's 2 positions. I think that's 3 positions. Are there any more? That does restore.
That brings it back to what we had before.
Yeah.
Okay. So last session we appropriated $300,000 for initiatives relating to Hawaiian language for Alelo Hawaii, including a position. How's that funding been used?
No, we've hired a person. Sure, the rest of it.
Good afternoon, Chair,
Afternoon.
members of the committees. Rod Miley, Administrative Director of the Courts. We have Ms. Johanna Chok Tam, who is the Director of the Olelo Hawaii Program. Ms. Chok Tam?
Is she outside? It's hard hearing outside. So you hired? Okay, here she is.
Oh.
Right now, up there. Aloha, my name is Johanna Chok Tam, the Olelo Hawaii Program Administrator. As I was walking, I just heard my title and I didn't hear
So the question was, we had appropriated $300,000 for initiatives relating to Olelo Hawaii last year, and we were just curious what we got for the money. So I guess I take it we got your position as part of the money.
Right. And then we do plan to, we do plan to go through our Olelo Hawaii documents that we have on file to make sure that we pull out the legal document, the legal language that we already have, because we want to establish a firm Olelo Hawaii legal vocabulary. So when we're using this language that it's standard across the board, we will be working on, excuse me, working with the universities to form a educational program to train more translators to service our needs and possibly other departments' needs as well. We will be working with the law school to train up our attorneys for the possibility of practicing in Olelo Hawaii. We will be working on recruiting more Olelo Hawaii interpreters. We do have the opportunity for Olelo Hawaii interpreters to join us, but we have been having a little bit difficulty of getting them on board. So we're going to work on getting more of them to join us.
Okay.
Yes.
My understanding is though that your base budget does not include, you're not asking for the $300,000 again? Does that mean your job is temporary, or how does that?
Chair, I believe that our understanding is that the position itself is permanent. And
Okay.
we've included that as part of our base budget.
Okay.
And then the operational funds we're not asking for. We understand that it was not included in subsequent years. So at this point, Ms. Chok Tam has been working with our RFP folks, trying to get the contracts out for the folks that will be assisting in the translation of the documents and the other services.
Okay. Okay, thank you. I have other questions, but if other members would like to go, I'm happy to.
Thank you, chairs. Just a few questions. In your vacancy report, it had 192 that were defunded. So does that include that vacancy report that's listed in table 11 to table 11? That's all. That it also includes the defunded positions.
192 that were defunded back in 2020, right? But some have been. We found funds to pay for some of those defunded positions, so it's not at this point in time. It's not a total of 192 defunded.
Okay. And as a follow-up to that, as I quickly glance to it, I noticed some themes. So social workers, clerks, judges. Is there an underlying common theme on why we're not able to hire those particular positions?
I can tell you, well, social workers especially are very difficult to hire, to find qualified social workers. That's just a problem. That's one of the major problems we have with hire when they don't stay, they move on, they go to higher paying. They are higher paying, but even finding qualified ones. Judges, if they were defunded, it's a matter of whether, we didn't have the money for them, obviously. New judges, it takes 9 months. It's just a long process when you hire, when you fill a judge position, because they have to go through various applications.
Right.
So it takes a while.
Thank you for that. And then the last question I had has to do with the HOPE program. So you did mention, and correct me if I'm wrong, sir, that there was no judge and that there were outstanding cases, about 130 through that program?
Yeah. The judge that was handling the whole program retired, whatever. So his cases were spread out among the other judges, and that was 123 cases.
123.
123 cases per judge.
So as a follow-up to that, does the judiciary have any intention to, I would say, for HOPE, to redo HOPE or go through that program?
Well, I best let say.
Thank you, Senator. We're looking at that. We're looking at the options. As you know, our treatment courts, which many of you are familiar with, are based on the treatment or the therapeutic model. The HOPE program in its original form didn't complete that particular kind of service. So we're looking to see how we can incorporate perhaps the good parts of the original HOPE with our therapeutic court model.
Okay. Thank you, gentlemen. Thank you, chairs.
Senator Kim.
I don't see a table on your teleworking. Do you have employees on telework?
Yes, we do, and we did submit that to Chair.
Maybe I didn't.
Since you know what page it's on.
I'm so sorry, Senator. We can also provide it to you.
Stacy, you know what page it's on.
Is that on here?
Yes.
I believe it was a separate request, Chair.
Yeah, but we added it to our
Twice.
file. Thank you. Oh, 452.
Okay, you come back to me after.
Okay. Senator Pavel.
I know you guys have the CIP budget you guys requesting and I'm looking at you guys nice ugly pictures of the stuff, but I get a concern. So I understand we're looking at these things and it's up in and putting them up. What is your maintenance plan or maintenance record on these items? Because we know that plan never follow, but just have a wheel there. So what is your guys' maintenance plan that you guys have when you guys, I mean, I understand it's old, but what was the last time did you guys know to have an actual plan on how you go through you guys' buildings and I don't know if that's tags thing or. Okay, you need to play with some Pringle? Sorry. Anyway, do you guys have something like that?
We do, sir. We have a list of all of our repair and maintenance backlog, the things that need to be done.
Who handles that? Is that tags?
Some of that, depending on the scope of the project,
Yeah.
we included in our CIP request. The other ones, we've been able to use our lump sum CIP
Yeah.
when we have that appropriation.
So it's like, that long, like with procurement or anything, having a bid out or any contract
It's
to
not,
do it?
I believe that it's more a question of priorities, and we try not to ask for too many things at one time. We want to make sure that we can manage those projects within the time that the funds would be available.
Yeah. But that's an air and circulation problem. I mean, I know you can go swap me and get some half fans, but I don't think it's gonna do it. All right, I just wanted to know if you guys had a plan. Thank you,
We're
guys.
trying to go through it. We have repair and maintenance backlog.
Thank you, Chair.
Any other questions? Senator Kidani.
On your restoring funding for 33.2 defunded positions, what is, in the Second Circuit, what is a .2 position?
Or it's a per diem judge, because per diem judges are limited amount of time they can work, so it's a point, they can only work so many hours during a week. I think that's like 8 hours a week.
And
So is
over
this
the
the
period-
only per diem judge you have, or several of them make up a full position?
Yeah, well, if you did that, 5 per diem judges make up a full position.
Okay, thank you.
Any other questions?
All right.
Go ahead.
I'll continue on then. So regarding the judgeship positions, we restored funding for 2 Third Circuit Court, I think last year, and then this year's budget asked for restoration of funding for 4 additional. If this latest funding request is approved, will there be any remaining unfunded judgeships?
No, I don't think so. There are any unfunded. Sorry.
After the, if we approve this?
No,
Okay.
as far as
So
I
how-
know, there are none, because we did Third Circuit last year. I don't think there are any other unfunded judges, no.
Okay. And then, so how many judges do we have statewide? I mean, I guess you can leave out the per diems if you have both.
I believe that with the new ICA judge, the Intermediate Court of Appeals judge that was added, we're at 82 or
It'd be higher, 83.
83, okay. So but that does or does not include per diems?
That does
That
not
does not
include.
Does not include per diems?
Yeah, when
okay.
we go through our budget thing with the judicial selection, the Commission on Salaries and stuff, we figure in 10 additional judges to cover the per diem judges throughout the state.
Okay. So regarding the grand juries, in a recent correspondence with the judiciary, the letter states that your letter states that Hawaii Revised Statute Section 612-16A precludes the summoning and paneling of additional grand jurors for the current calendar year. But the statute seems to say something different. The statute says the court shall order 1 or more grand jurors to be impaneled at such times as the public interest requires. Why are we talking past each other on this one?
I don't believe there is a conflict anymore. I think there was one interpretation that might have caused us to limit when we can impanel new grand jurors. I think we got past that, and toward the end of last calendar year, we actually had increased the number of panels.
So you actually impaneled some new people?
Yes.
And in December?
Yes, and we also increased the number of grand jury sessions for each of the panels as well.
Okay. How many new panels did you institute, or?
I believe it was between 2 and 4, and what they had done was the grand jurors.
So would that be 3, or you don't know whether it's 2, 3, or 4?
I'm sorry, we can get that information to you.
Thank you.
I believe it was 4, but I don't want to misstate that.
Okay.
And that was made up of jurors who were first selected and then held as alternate jurors, grand jurors. And then what the courts were able to do, our chief judges, was to take those folks and constitute separate panels so that we're able to increase the number of grand jury panels.
Okay, so at this point, you don't think that there's a disagreement between us on, you have to do certain ones by the 15th of January, the initial
Yes.
impaneling, but then after that, if there's a public interest involved, you're comfortable with impaneling more?
Yes.
Okay. So the judiciary, of course, was heavily impacted by the pandemic. At this point, are there any remaining closures or restrictions at courthouses?
I do not believe so.
Okay, but you're still requiring masks for
Yes.
for jury deliberations and things like that. Okay, but nothing's closed.
Nothing is closed.
Okay. I think I just had one last question. That was table 16 regarding the CIP lapses. Shows a significant amount of unused funds for furniture and equipment at the Kona complex. It's a $1.5 million. What's that about?
Hard to hear. Joanne, it's about the $1.5 million loss at the Kona courthouse.
Kona courthouse at table 16, it seems to say 1.5 million unused funds for furniture and equipment at the Kona complex, and we're just curious what that was.
Okay, so I'm Joanne Cripping. I'm Capital Improvement Administrator for Judiciary. I can take this off. So we had more funds than we needed. So we
I think
lapsed.
that's the first time I've ever heard that.
Two.
So you lapsed it? You lapsed at 1.5 million? Okay. All right. All right. Thanks, Chair.
Senator Kim.
Yeah, I can follow up on the remote. Is there a policy that you folks are following?
Yeah.
Because, like I noticed the reasons and accommodation, request for reasonable accommodation.
That would be under our Americans with Disabilities Act. So when folks have either a permanent or a temporary condition, that might be an accommodation if they're not mobile or they have other issues with their workplace. So
Was
to
this
allow
also
them
in effect prior to COVID?
that was relatively recent, but we could have made those accommodations even before COVID. So our policies before COVID, we had a telework policy that was very
Can you
very
speak a little louder?
structured. Before COVID, we had our policy, which was very structured. During COVID, we were more flexible. We have since gone back to a modified version of our telework policy. So you have to be able to perform all of your work-related duties, including the productivity, the accountability, and the response time that you need to maintain. And so that is the current requirement to participate in the judiciary's telework.
And who does the accountability? Who does the productivity?
That would be up to the supervising administrators to make sure that workers who are on telework status are fulfilling their responsibilities. And if they're not, it's something that can be rescinded.
How often do they monitor this?
I guess it would depend on what the particular kind of work is.
Okay, because I see promote work/life balance, performance, productivity, your normal business hours. Are you folks all jury trials are back in person?
Yes.
And so how do some of the judges do remote work if they're?
Judges do not, nor do their staff. Many of the
So judge assistants, associate judge, they're not, I see them on this list.
That one might be the Intermediate Court of Appeals, so as opposed to our trial judges.
So
The trial judges are all in person, and they,
Intermediate Court of Appeals, they don't have to be in person? I mean, they don't have to be present?
they are able to work remotely.
I also noticed that several pages where it says 1 day, 1 day, 1 day. Everybody on that page is 1 day. It just seems like people are taking 1 day off, just putting the work all in 4 days and taking 1 day off.
Okay, we're very clear that teleworking is not vacation. Your responsibility to respond to telephone calls, to electronic communications, and to produce the work that's required as though you were in your office. People who are not fulfilling that, again, would be subject to having their agreement
I
rescinded.
understand, but if everybody can take
then everybody, should be able to take one day off, because it's, according to what your explanation is, employer able to assign duties and responsibilities effectively while on telework status. So technically, everybody can probably do this one day in the entire state government.
Our experience is not. For example, for courts, they're in session every day, and the folks that support the judge as well as the judge, him or herself, would need to be present.
So these people that can only go one day, but the other 4 days they can come in,
Yes.
right? It's interesting. So and then it says, so how often do they reevaluate them? Because it does say until subject to review, expected to continue till subject to review. When is that subject to review?
Again, we have annual performance evaluations. That would be one timeline. So everyone gets an annual performance evaluation.
They can be on telework for a whole year before they get reviewed.
Well, we know that that's at least an annual review. But for folks that are production-based, that means that you have to account for whatever your workload is. That would be on whatever period of their work submission.
So if you're not on a production base, you can be on telework without being reviewed for a year?
I would not think so. I think that would have to be more frequently than that.
Can we see and is it consistent across the entire judiciary?
We have a core requirement, and if you would like, I think we can provide that policy to you.
Yeah.
But again, if someone is not performing, we're going to know that very soon, because calls that go unanswered become somebody else's problem. The people who are not being productive the way they should be, then that's not in.
Yeah, but at what point do you know that when you're going to complain? I mean, we've been asking this of, Chair's been asking this of every agency and department that's come in here, as to how consistent you are, what are performance measures, how are you determining this? And, to wait 1 year for a review, I mean, that's kind of long.
Yeah, I'm sorry if I gave you that impression. It's not 1 year. That 1 year is the evaluation, the annual evaluation, and whatever the accountability is between that time period. For some folks, it's weekly. For some people, it's monthly.
So if they're not on a performance base, how are they measured? They're not on performance base, how are they measured?
That would be up to their supervisor. Again, the only kind of work that we do has some production base to it. Whether it's on a specific project, whether you're reporting to, whether it's cases, whether it's reports, those are the kinds of things where the same way you would be at work, if you're responsible for producing work to you're responsible for producing work according to your work unit and to your work program.
Okay, I'll look through this some more. Thank you, Mr. Chair.
But you have some kind of metrics for productivity?
I think it's the other way around. When your productivity doesn't match what you should be doing as though you were in the office, that triggers it.
Okay. So there's some type of agreement of what needs to be accomplished between the supervisor and the... Any other questions? Okay, we're gonna take a recess so we can have Attorney General come on. Thank you. Okay, reconvening the Committee on Ways and Means and Judiciary. Next, we'll hear from the Department of Attorney General, who will present their biennial budget. Good afternoon.
Good afternoon, Chair Dela Cruz and Chair Rhodes, and members of the Ways and Means and Judiciary Committees. My name is Ann Lopez. I'm the Attorney General. With me today are Julia Bato, of the Crime Prevention and Justice Assistance Division, Lynette Lau and her CFO of Child Support Enforcement Agency, Philip Higdon of the Hawaii Criminal Justice Data Center, David Moore, the department's Administrative Services Manager. I'd also like to introduce my first deputy, Matt Devanch, and my special assistant, Dave Day. And also with us today is Kristen Johnson of the Hawaii Correctional Oversight Commission. My thought this afternoon is to not repeat the testimony that we have submitted to you in writing already. Rather, I would, with the chair's permission, like to spend just a few moments providing you with a status of the Department of the Attorney General.
Well, you don't have any budget requests?
We do.
Maybe you do that first.
Oh, since they were in I just didn't want to repeat the whole request. But I'm happy to.
Go ahead and repeat them, yeah.
Because that way people understand why we have questions.
Okay, got it. We have a relatively modest request that you'll see on table 4. And I did not bring my reading glasses.
That must be a thing nowadays.
We've had them before.
Yeah. You bet.
Well, I didn't bring them, so I'll just hold them far away. Or actually, I'm going to go to table 6, where some of them are as well. On table 6, on the second line, is the supplemental full year new position funding. That would be fantastic.
Okay, so remember, that's our page 325. Yeah.
With these excellent glasses, I can go back to table 4. I'm sorry.
No, you can do 6. That's fine.
Okay. The supplemental full year new position funding, our fringe allotment correction, which I believe is just mostly an accounting correction, the litigation fund of $470,000 both years. The e-grants management system, which is for the Crime Prevention and Justice Assistance Program in its modernization plan, and division staff for the Crime Prevention and Justice Assistance Division. We also have a funding request for $250,000 for furniture, which I have pulled from our budget, and we are no longer requesting. All right, that was an emergency appropriation that we're withdrawing.
Okay, so those are the things that you're just going to highlight from your request, or those are the only things left in your request? Because table 6 says more than that.
Correct. The items that I've just highlighted are those that the governor approved and came down with the steady state budget. There are a couple of items that we're talking to Budget and Finance and Governor Green about.
This list has both.
It does. When we had initially when we received the instructions about what we were looking for, we combined those things. And weren't sure if you wanted just what the steady state had, or all of our requests, or all of our requests plus what we're asking the Governor Green's administration to provide.
Okay, well, normally we just go over what's in the bill, the budget bill. The rest would have to be a legislative ad. So maybe you guys can resubmit and to separate the two.
Of the items we're talking to about now with budget and finance and the governor?
Yeah, because those, it's...
Right. I understand that will come down separately from the governor and budget and finance.
Yeah, but those new items, or I guess what you, if you want to call it green items, those would actually have to be legislatively added to the bill.
I see.
Is it the budget bill already is submitted?
Right.
So table 4 is the first that is under the EGA administration.
Correct.
And table 6 is both EGA and your new request.
just the EGA steady state requests.
Table 6?
Yes.
Oh, you read only a few of what's on there.
Right, and those are the ones that I read are the ones that Governor EGA approved. We are not going to push hard for any more additions.
So the staffing for what is that? The Special Investigation and Prosecution Division. You're asking for 1.5 position, 92,000.
We've actually have staffed our attorneys, our analysts for that. We still have we have a total of 8 investigator positions, and we have only been able to fill 1 thus far. So we're working to fill those investigator positions now.
So this is no longer needed then?
Correct.
Okay, maybe you guys can resubmit
Wait just a moment. David is going to jump in.
Because it's hard to, I'm getting confused as to what you really need.
I'm sorry, Chair, that's my error. I should not have included all of those items on that list. It was my understanding that everything requested was supposed to be on there, and I misunderstood. And when it comes to SIPTI and all the other budget requests, those were requests made by the prior administration and prior AG. And since then, the new AG and her staff have reevaluated and reprioritized those requests that will be coming down with the governor's message in February.
Okay, so if you look at table 6 then.
All those other items should not have been on there.
Okay, what do you really need then off of this?
Of what's on table 6?
Yeah, why don't we just go line by, it's not, you only have the 2 pages.
Okay.
So why don't we just, you don't need the SIPTI staff thing.
No, that's going to still be priority number 1, and the request is going to change quite a bit.
Okay, so for members, if you just look at the 4th column, it says program ID priorities. That way we can all just get on the same page. At least that's a reference point that we all can look at. Okay, so that's number 1, you still want that?
Yes, but it's going to grow quite a bit.
Okay, so that's going to get changed from 1.5 to what?
It may go to 2.5. It's not the number of positions, it's the way of funding. Reason like investigators, the reason we can only hire 1 is we think that the salary is way understated for the competency that we need.
So how many people do you really need?
Well, like I said, I think we're only going to ask for either 1.5 or 2.5. Right now,
And then what would be the salary amount?
Salary amount for forensic specialist is
right now you have 1.5 at 92,000.
Yeah, so the new request goes up to about 246,000, and then a little bit more in out year.
Okay, are you guys going to resubmit this?
Yes. With the Green administration budget.
200,000 on what position?
No, that's salaries of the 8 investigators. The
200,000 is for what?
investigators are budgeted at 60,000, and the kind of people that we need are going to require quite a bit more.
So how many more positions are you going to ask for the 200,000?
Same amount, right?
The same amount of positions, we're gonna ask for salary adjustments,
So 1.5, but you want 200,000.
but
I
that's,
understand what you're saying, but that's the correct, so that 1.5 will stay the same, it's just the numbers can go up. The
Yes.
salary amount.
yes,
Right, so
not for the 1.5 positions, but for,
I thought you said 2.5.
I'm still negotiating with the supervisor.
So would it make sense for you guys just to send us another document that says what you're asking for, preferably before the administration's asked, so we know what's going on? Because February is pretty close, but it's not. We got to start moving bills.
How are you sending it down? Is it a governor's message?
Yes,
Okay, because then if that's the case, what's going to have to happen is we're going to have this hearing with inaccurate information, and then we're going to have another hearing on the governor's message and do it twice, versus if you just give us the correct information, then we can have the hearing.
if I could get that approved by the governor's office.
Yeah, but what are you asking for? That's what we want to know.
A lot of the money would go to salary increases for the investigator.
Is that the only one that's not the same? Are the rest the same? Or are amendments throughout? You need to make changes throughout the whole list.
Many of them are the same, but there are other changes.
Are you new at this?
Pardon?
Are you new?
No.
How long have you been there?
17 years.
17 years, and you're giving us like this.
This change of administration was a little bit different.
Yeah, but our request is our request, it's not different.
I've been told to hold it.
I told you to hold it.
I think that came down from the governor's office.
Well, if you don't tell us what you need, we can't
Yeah, we're not
help
gonna
you,
give it
so.
to you.
But
The governor-
he hasn't given it to us yet.
Oh, we wanna know what you asked, we're not
He
saying
doesn't
what.
know your budget and what your needs are.
Yeah.
So that's what we're trying to ask from you.
That's why I was saying the safe bet is to at least go over the EGA's request. Then you can do a second sheet of all the things you're asking the Green administration to send out. So you would have two sheets, the EGA request and the Green request. But at least we know what's in the budget bill.
Okay.
Okay, you know what? We'll give you time. Chang, when can we? Yeah.
Gonna come back.
What they're giving us is not what they want.
They're asking if they can use the word about the state on table for that.
Wish I had you. Sure, you'll be ask some other questions.
Yes.
Go ahead.
Aloha, I have a question for the Attorney General.
We're still at a hearing.
Okay, I apologize.
Hello. So in your budget submittal, you're requesting $470,000 for ongoing litigation expenses.
Correct.
Do you have some sort of explanation for what that's for?
Yes.
Okay.
We have generally maintained a litigation fund. I believe under Attorney General Connors, there was work with the legislature to use some of those funds to create 2 new positions, which decreased the total amount of our litigation fund. Well, our trend of you're not Chris Lee?
Sorry.
Well, our trend of litigation has not increased that much. The complexity of litigation has increased, and some of that is due to electronic discovery, which requires much more manpower and much more time. to complete. In addition, recently, or since the Bruin decision on firearms came down from the Supreme Court, we've had an exponential increase in the number of firearms litigation. Those cases do require expert witnesses, and we anticipate that those cases are not going to stop. And if the AG's office is introducing a firearms omnibus bill this legislative session to clean up our current statute and make it consistent with Bruin, but still retain as much of the strict laws that we've had, we anticipate that there will be more litigation.
Okay, just to follow up on two pieces of litigation, I'm interested in understanding whether they've been resolved already. The first is the Kalima settlement that we funded last year.
So the Kalima settlement that you funded was $328 million. Of that, the attorneys can, I guess, get a maximum of $28 million. The AG's office isn't actually very involved in that process. The plaintiff's attorneys are working with the plaintiffs and a special master assigned to the court to make a determination as to how that $328 million should be divided amongst all of the plaintiffs.
So okay.
So it's ongoing. We just don't have a view into what's happening on a day-to-day basis.
Okay, thank you. And then is the Department of Health whistleblower legislation litigation still ongoing?
I don't know the answer to that question.
Okay, if you could follow, I would just like to know.
We can get that though, because we'll reconvene on the 24th at 10 a.m.
Oh,
so
so this is regarding the whistleblower retaliation lawsuit filed by Dr. Jennifer Brown during the COVID pandemic.
Okay, I do not know anything about that case, so I'll follow up with you on that.
You know, obviously, if you're still in litigation, you can't maybe share a whole lot, but I would like to know if it was resolved or not.
Absolutely.
Okay, thank you. Thank you, Chair.
Okay.
Can we ask more questions?
Yeah, go ahead.
Oh, can we go to your 89-day hire?
I'm sorry.
Your 89-day hires?
Certainly.
I see where you have one that's been appointed 75 times in 89-day hires, 68 times, 53, 36, 11, 6. And those are your investigators.
Correct.
We've had this conversation before. Have you been with the AG's office? I'm sorry, I don't know your background.
I'm really having a difficult time hearing you. I'm sorry.
I'm sorry. Have you been with the AG's office long? I'm not familiar with you.
I was just appointed and started December 5th.
No, but have you been with Deputy AG?
Prior to that, I was the special assistant to David Louis for 2 years. Otherwise, I have not worked.
Okay.
Prior to this, I was the general counsel for Hawaii Health Systems Corporation.
Okay. So I just want to get a sense how much I would expect you to know. So the 89-day hires, we've had this issue about 89-day hires.
Correct.
I mean, an 89-day hire does not mean you hire them 75 times at 89-day hires. It's supposed to be for emergency type hires. And I know the concerns and issues with getting investigators, but still, I mean, come on, 75 appointments, 68 appointments. What are you going to do about that?
The investigators that we've hired are, at the moment, all men who have retired from one of our county police departments or a mainland police department, or in some cases, the FBI. If they were to receive benefits, be hired with benefits, they would jeopardize their pensions. And so the only way to hire them as a non-benefit earning employee is through the 89-day hire.
But was that the intent of the 89-day hire? Was that the intent of the 89-day hire? And if it's not the intent, then either the law needs to be changed or you need to figure out some other way.
I don't know exactly what the intent was behind the 89-day hire. I just know that the only way we've been able to get investigators is to get retired police and FBI.
Okay, well, again, the 89-day hire is not intent. and it states it in the law, it's temporary. 75 appointments is not temporary.
I agree.
So you need to do something about that. I mean, you are the Attorney General. You are supposed to uphold our statutes and our laws, and obviously it's not happening in this case. And I will point out others later.
I will say, without the 89-day hire, we would be short, I don't know how many deputies.
We have 8 right now. And last year at this time, when we brought the subject, you brought the subject up, there were 14. And 6 years ago, we had over 40. So we've been working hard at it. We just haven't been able to completely get there.
So the highest amount, 75 times, we're not able to fix that. Okay.
Well, there's 2 on there. 175 times 168.
I know. Okay, can we go to your remote workers?
Absolutely.
So is that a new benefit we have now for all workers, that they use, you're using remote work as a job incentive benefit?
Well, of course.
Retention benefit?
Yes, of course, it all started with COVID, but now, because we currently have 194 deputies, and we have 31 vacancies. Last year, the legislature appropriated a very generous sum, so we were able to give raises to retain our deputies and to bring some more deputies on board. With the sort of not invention, but with the beginning of remote work, we put in place a policy where deputies could not work more than at home or remotely 3 days a week. They are all required to maintain timesheets that identify how much time they're spending on what their projects are, and what kind of work they're doing and for what client. Their supervisors are required to review those timesheets on a weekly or monthly basis, depending on the kind of work that's being done. And they have done so. We have had some supervisors who have brought deputies back in because they weren't being productive. I brought some copies of the timesheets if you'd like to take a look at those, but they are being monitored.
Oh, but what are the metrics that you're using? Because an experience that I experienced with some of the jobs that have been sent or cases that have been sent to the AG's office, they've taken like 6 months or longer to respond to things. They've held up a lot of the procurement protests. And so I don't know who's monitoring them and what kind of matrix you're using to determine whether they're really doing the work. But there was an incident at the airport where they referred the protests to the AG's office. It was over 6 months. When we met in the hearing, I brought it up, and 2 weeks later she brought it out and it was dealt with. But it had to take us bringing it up for them to look into it, to wonder why this simple protest was taking so long. And I can raise other specific cases, but obviously there seems to be some backlog. And so to say that, we're holding them accountable and their productivity, I have serious concerns.
I agree, you should have serious concerns. That was before my time here. My expectation is that you will no longer have those complaints. We will be responsive, we will be transparent, and we will take care of business. The fact that we are down 31 deputies makes a very big difference for us. And in addition to being down, we have today 36 deputies who are eligible to retire, and in the next 4 years, 20 more. So we have been working very hard to increase, to recruit and retain our deputies. And so the telework is an important perk.
But that's not the intent of telework, to be a perk.
I would
Do you
I would respectfully disagree and say that in today's post-COVID world, remote work has become a common perk in both the public and private sector.
So is that the policy of the state in our remote work, that it's going to be a perk? Because if this is the case, then it's across the board. Is it going to be one of the items that is going to be negotiated by the unions as a perk benefit?
Certainly not in the Attorney General's office.
But you're doing it without that. I mean, you're obviously saying it's a perk.
For all of our exempt excluded employees.
Then if it's okay for the exempt, then why isn't it okay for the rank and file?
Many of the rank and file can't do their work from home. They need to be in the office. Not in our office, I'm afraid. Paralegals are dealing with documents. Legal secretaries are dealing with...
Can't they do that from home?
No. We can't have thousands of documents taken home to be reviewed. Lawyers have been working and keeping timesheets.
Okay, can you send us your policy, please, of what?
I will bring it to you. Would you like any copies of our timesheets?
You can submit it. We'll distribute it.
Okay.
Send to Pavella.
I don't know if you guys been watching the hearings. Maybe you guys not. Maybe you guys don't have a YouTube channel. But this is the same things as being asked from my colleagues over and over again. To tell us, perks, and then you try to tell Senator Kim that they cannot because of documents. Well, human services and all the other departments have sensitive, private issues just as much as you guys do. So you pick and choose. Seems like the department or you pick and choose who can and cannot work remotely, because all of these departments all have sensitive documents and private issue, but they do everything through remote, through email. So just saying that the paralegals cannot do this, it's your assumption that they cannot do them. So the thing is, before you guys come over here and start this thing up and making me get high blood pressure, and how you guys are trying to justify the wrongness of what you're saying, perks. Got a job, COVID is over, get over it, come to work, because when you tell me, oh, I cannot come work COVID because I don't want to take the disease home, I get 2 elderly people that I take care. I am the primary caretaker on paper. I'm here every day with my colleagues, and I go home and I do my job and I take care of my family. I don't like hear this kind of stuff already, because why? Half of the world in this whole island, everybody look at us, look at me idiots. Most of our state workers are working from home, making a joke of our taxpayers' money. That's serious. I think that's serious. That's criminal. I think we should make a bill. If anybody was those charges to the Attorney General, put them in jail because they're stealing from our taxpayers. Nobody, not even my staff, I tell them the same thing. Not even my staff work 8 hours. Maybe Donovan's different. My staff don't work constantly 8 hours a day. If they're doing that and they tell me that, I tell them they're lying. Pack up your bags and leave. Nobody, not even the people you have out in the field, constantly working 8 hours, constantly being monitored by their supervisors or whatever, and timesheet. Timesheet is nothing. I can erase some aid. I can erase them. You know what I mean? That kind of stuff. That's not justifiable what we're asking. What you guys should do is revamp them, come with a good plan, present them to my colleagues, and then you can justify it. But don't go off in the air, because you guys have no matrix. Over and over, Senator De La Cruz says, what's your guys' matrix to monitoring them? Well, they get a timesheet, or maybe once a month the supervisor look at the timesheet, or some of them have called back in. That's not the matrix. That's not the process. So go back to the drawing board, wherever you go, and come back and bring back something that is concrete, or was inside whatever the law, whatever for remote working, and give us something that was done that way. Not the way you guys are saying them. Every single department, 700 one of them get, because I don't like driving through traffic. That's a perk. I drive traffic every day, and I still take care of my elderly family members. But that should not be a perk for work for the state, that you get a choice to go work at home because your department said you can. That's a perk. Because if that's the case, they get plenty of union members, like their members work from home too, and we're gonna put that inside of the procurement for them to do that same thing. I just tired of that, man. I'm serious, guys. You guys gotta figure something out on how you guys gonna do your guys remote work. Because that shouldn't be a perk for them to work. A perk is to have a state job have a good job, good paying job with benefits, that's the perk. Not because they're gonna be working from home. Sorry, Chair. Thank you.
May I respond? I don't disagree with some of what you're saying, Senator. I'd have to figure out what kind of a matrix that we're talking about. Right now we have 31 vacancies. Some of our deputies stay on the job because they can work remotely 1 or 2 or 3 days, or even a half day. We do look at we take the time sheet seriously. Lawyers have been doing time sheets since the beginning of time in 6-minute increments, in 10-minute increments. I'll certainly consider and think about what kind of matrix we could include. And finally, I'd just like to add that the people we're talking about are exempt excluded, so they can be fired. If they're not doing their work and their work product isn't satisfactory, they can be fired, period.
But that shouldn't be stated as a job retention incentive. And if you're saying that there's certain people that have sensitive documents or documents that, client privilege, you have all these deputy attorney generals that are on remote. You're telling me they're not taking home these sensitive documents? You're telling me that the forensic analyst was out for 3 days, or deputy attorney general out for 5 days, or forensic analysts, that they're not taking home sensitive documents?
I can't promise that that's the case across the board.
Well,
I think most attorneys can work electronically.
Yes, but you made that thing where certain of your other employees cannot work remotely because they have these sensitive documents. You said that yourself. So I'm just trying to take your argument and putting it on these people and saying they're not taking home sensitive documents?
I would hope that they're not taking home sensitive documents. I can certainly find out. I think that one of the differences between a paralegal or a legal assistant and a legal clerk is that they are subject to collective bargaining. With the exempt excluded employees, we are able to, if I don't think any of them work 8 hours solid. I don't think any of us do. We get up, we eat, we drink, we talk with people on the phone.
We wash clothes.
So people don't work 8 hours and then stop. But attorneys have been successfully working independently and getting their work done, whether it's at 2 o'clock in the morning or 12 o'clock at night or
I understand.
at
I'm
8
just saying
a.m.
that putting down job retention incentive is not a good reason here, and it sets a precedent for every other state worker or every other state benefit. If the Attorney General can use this as a job retention incentive, then why can't it be done for everyone else? And I think you really need to take a long, hard look at these kinds of stuff that you put down. And if you're going to tell me in certain situations of people that there can't be on remote because they have sensitive documents, and then don't hold that same consistency with other, so for 3 days a week, these deputy attorney generals can't take home anything sensitive. They're not working on those cases. I mean, so, I'm just holding you to what you're telling me. So when you give us these kinds of reasons or excuses, then I'm going to hold you consistent to that.
That's fair.
Across the board.
That's fair. I'll just leave it at that the documents that many attorneys deal with are electronic. So they're not bringing paper home. But I understand what you mean.
Thank you.
I'll also just note in terms of retention that I think for a lot of the folks coming into the workforce today, working for 30 years at one company is really not their focus.
But you're not the only one facing that. We all are.
Exactly.
So
what I'm saying is trying to find new ways to attract talent to come into public service, make less money than their counterparts in the private sector, is an important part of what we have to do.
Right, but before you add on incentives, that is not part of the overall state policies, you have to be careful what you do because it affects everything else. So for a department to pick up a benefit or incentive on your own without running this through the channels or the policies, I think, you have to think twice about these kinds of things.
I will do so, and we will try and work with DHERD on how we might be able to do that.
Thank you.
Okay, we can move on from that Delaware policy. I think the main concern is just making sure there's consistency across the board on matrix and showing that productivity is being achieved.
Absolutely, I don't disagree with that at all.
Yeah. I think the DHERD director is going to try to find something that's going to be consistent for all departments. There may not be one program that matches every single situation.
Right.
So she may have to find 2 or 3 types of ways on how to measure productivity depending on the type of job, that hopefully she can find something that departments can use, at least access.
Right. I understand that she's going to be presenting something this week to the cabinet to help us both with that kind of issue, as well as trying to find some faster ways to post and hire employees.
Okay, the only question I had though is, what we try to find, especially on the employees that majority of the time are teleworking, how are you dealing with the space requirements? So sometimes you have communal desks that they're going to be able to use, or do they still get to keep the exact same required space of someone who's always there?
I appreciate that question very much. I have been telling people that instead of going out and renting more space, we have to consider time sharing our offices. If you're going to work from home for 3 days, then you don't need an office to yourself all week long, 365. It's not a terribly popular statement to make, but I absolutely believe in it. It's partly why we're withdrew the emergency appropriation, because I just don't know that renting more space is what we need to do.
Senator Rhodes.
Thanks, Chair. So who do you compete with when you're hiring people? Who are you competing with? Corp counsel, private sector, federal government? Who do you compete with for attorneys primarily?
Certainly you see a rotation of attorneys who want to work in public service. You see the churn from prosecutors to corp counsel to AG. Generally not the federal government. Certainly private practice.
Are the people you're competing with, do they allow their attorneys to work at home?
I'm not sure. I know my first deputy came from the prosecutor's office, so I will.
Does the prosecutor allow people to work from home?
Prosecutors are generally employed
They can't really. Does the private sector? I haven't worked in the legal private sector in a long time. We just worked all the time, so it didn't matter whether you were at home or not. But
exactly, many firms do allow remote work, and in fact, it's a very active conversation amongst law firms about how do you develop a culture, how do you mentor people, how do you ensure that the work product is good. And so yes, working from home is considered.
But you would view it as a competitive disadvantage if you couldn't offer that?
Correct.
Okay. So, looking through the documents, it wasn't clear to me, the sense is it's a very status quo request and status quo view of what the department does. What's going to be different what's going to be different under you as the AG? What's the vision? What's going to change?
I think the first thing that's going to change started with your appropriation to give raises to the attorneys. They were the lowest paid government attorneys for a very long time. So I think that that's one thing. I have sort of a parallel vision of what I want to do within the department. I'm already changed, for example, the way that deputies should be interacting with the legislature during the legislative session with bills and testimony. I don't want any deputy surprising you with a piece of testimony that says they have a problem with your bill. You need to know about it as early as possible and in advance of any testimony being submitted. I'm working with my special assistant to find ways, excuse me, to find ways for our deputies to get recognition for the really good and hard work that they do. I think you saw today, Chair Rhodes, that we had one of our appellate attorneys provide the sort of the talk for the Roe v. Wade rally. It's that kind of thing. I don't need to be front-facing on those. I want the deputies to be doing that and their supervisors. The parallel tact for me is to reintroduce the Attorney General's office to the departments and their directors and deputies and let them know not only what we do, but what we're supposed to be doing, along with my commitment that we will change the way we do business. And by doing so, part of that is my working with the supervisors, getting feedback from directors, and I have gotten feedback from directors where they've been very unhappy. And similar to Senator Kim's complaint, it takes too long to get what they want, or what they want isn't exactly what they were asked, what they received. And I'm gonna enforce a stricter code of work product, and so that the feedback that I get from the departments is that we're doing good work.
Okay. So on page 3 of the budget narrative, the department's response to item B, how our requests contribute to accomplishing our strategic objective goals and performance metrics, states, we continue to focus our requests on utilizing special funds and conserving general funds where possible to prioritize the needs and provide effective services to our client agencies. I'm not sure what do you mean? What are you doing that would do that? I can see the utility of conserving general funds, but what do you have in mind here?
Well, for example, most of our deputies who work in the transportation division are funded by DOT. And so what we're trying to do is make sure that we develop the relationships with the departments so that they value the work and they pay the salaries for those particular positions, not actual people. So that is a big part of it. With our Medicaid fraud unit, there are special funds. There was a dip in the last, I think, year, but prior to that, they have collected a sufficient amount of funds to not only pay for their department and overhead, but to put money back into the general fund. David, do you have anything to add to that?
Yeah, Medicaid group is 75% federal funded, 25% general funded for the last 2 years. One of the budget requests we're submitting to the Green administration is to go back to special funds. They are slowly building up a balance into that special fund, and we just had a recent settlement which will finance them for at least a year and a half out of that special fund.
Okay, so that was another one of my questions. So you're seeking additional funds in 4 permanent positions, but you're also proposing to reduce the unit by 4 permanent positions. So
that's a trade-off between general funds and special funds.
That's what you're talking about.
Yes.
Okay. I have more questions, but if you want to send it to somebody else first, then.
No, you don't want to come back on Tuesday.
Look, well, we can, but I can take care of most of it today.
Okay.
So okay, if it's all right. Okay. So page 3 of the budget narrative, the department's response to item C, how current statewide economic and fiscal conditions of effective operations and the ability to meet goals, states, the fiscal crisis caused by the COVID-19 pandemic has required us to evaluate all our divisions and units to find efficiencies and cost savings. To achieve this, we have worked closely with client agencies and our staff to reduce their need for attorney services. we recognize that certain compromises have to be made, but we'll work to ensure that our core functions providing solid legal advice and support will not be jeopardized. What does that mean? What compromises are being made? I mean, or is this sort of the legal analogy of having physician's assistants look at patients as opposed to having a doctor?
That's not what I would describe. I think what the compromise is what my vision is that rather than working with a client, let me just give an example as a contract. We get a contract from a client, we mark it up, we send it back. We get another contract from the same client. Oftentimes we're marking up the same thing and sending it back. It's a waste of everybody's time and efficiencies. One thing I'd like to be able to do is to have our deputies work with our clients foundationally so that when we get those contracts, we're not just seeing the same mistakes over and over and over again, that we change the way they do business so they're more efficient and they don't necessarily need our services as much.
Okay, but I mean, it sounds like you're saying that we're just not going to provide as many legal services. I mean, it can be interpreted that way. I'm not sure that's what you're really saying, but
absolutely not.
Okay. So
No.
you're hoping to just take care of problems before they become more time-consuming than they are already, and not repeat yourself over and over.
Correct. Currently, there's a couple of things going on that we're doing that with public housing and the projects that they want to proceed. Rather than having our deputies look at things after the fact, we have 2 deputies who are experts in both land and public housing and financing, working with that department now, so that they're working on the RFQ with them and working on all of those foundational documents so that later on there isn't a discovery that there's a problem.
But your position is that you're not providing less service, you're just trying to do it more efficient.
Absolutely, yes.
Okay, so you're not pulling away from certain clients, I mean, certain departments?
No.
Or the legislature, or, okay.
No.
Have any of the departments or agencies had to go outside of the AG's office to get legal representation?
Sometimes we do go outside. Even the AG's office goes outside when we have very complex litigation. Especially when it may be multiple large defendants. For example, Jewel is one of the examples that I can think of where we brought in outside counsel. That's the e-cigarette company. And we brought in outside counsel for that because those companies can just drown us in discovery requests that we simply don't have the capacity to meet.
Okay. Following up, similar to the Medicaid fraud question before, but there's a similar thing going on with the Law Enforcement Standards Board. 2 permanent positions are requested to be added and 2 are proposed to be reduced. Is that a funding?
We're just changing program IDs.
Changing program IDs. Okay. And then it looks like you're on table 11. It looks like you're asking for 3 new deputy attorney generals, but you have 15 vacancies already. So does it make sense to ask for 3 more when you already have vacancies?
Those are 3 federally funded. We got a recent grant.
Okay.
For second
so
offender.
It's a separate funding. Okay. And then one last question about do you anticipate additional litigation because of the Bruin case, the U.S. Supreme Court case about carrying weapons in public?
Absolutely. I think, Dave, am I right that we've already had 10 cases?
So some of them were pre-Bruin. Well, my name's David Day. I'm the special assistant. Before I became a special assistant, I served as a deputy solicitor general on Second Amendment cases. I don't know the exact number of cases right now. I can say that that are currently pending. There were some that were pre-Bruin that we actually, I believe one specifically, we prevailed on, and then I believe it was going up to the Supreme Court, and then we prevailed at the Ninth Circuit. The U.S. Supreme Court in Bruin came out with its decision, and then our case came back down. It was called Grant Vacated Remanded. And I think that several of the older cases have been reassessed. Since Bruin, we've had one particularly important and significant lawsuit. It's called the NAGR case, National Association of Gun Rights versus the Attorney General, in which they seek to strike down two very important statutes. One of them concerns assault pistols, claiming that that's a violation of the Second Amendment to prohibit the possession or sale of assault pistols. And also with respect to large capacity magazines, and saying that the limit in Hawaii on the sale of magazines of only up to 10 rounds per magazine is unconstitutional under Bruin and the Second Amendment. These cases have been proliferating around the nation in every single state in which there are what I would call, robust gun laws all along the West Coast, New York, the Eastern Seaboard. And in those instances, these are basically almost like cookie cutter lawsuits because many of the lawsuits are the same in many respects. But the way that these cases have been defended in light of Bruin and its specific test relating to determining and placing the burden upon the state to determine whether or not a specific gun regulation is consistent with the nation's history and traditions is one where every single state that has been doing its job in its defense has been employing expert witnesses and significantly, actually quite a few expert witnesses in order to establish the history and also the way, even linguistically, how, whether or not something fits within the definition of arms. And so this is something that we've seen absolutely proliferate nationwide. There are probably, things that are going to be coming down the pipeline that I could speculate upon, but.
Okay. I don't want to ask you to speculate about that right now anyway. So, but you are asking for extra money for litigation in partly in anticipation of these challenges?
Yes.
Okay. Okay. Thanks, Chair. That's all I got.
Chair, just a quick, what is an assault pistol? Sorry.
So it has a very unique definition in Hawaii. It's a statute that I don't recall the exact statute by number right now. It's a weapon that has a specific, I believe, two of approximately 5 or 6 characteristics. My understanding, and this is I'm just going to give you an explanation of kind of my understanding, is it would be a AR-15 with a pistol grip. That is what I believe is covered by that.
Thank you, Chair. All right. Okay. All right. Thank you.
Okay, we'll recess. Oh, go ahead.
Just one quick follow-up into the line of questioning from Chair Rhodes on your special, or I should say your funding for outside litigation. Where's that in your budget, or do you know that amount?
We've asked for $470,000 for this year and next. And if you look on table 4, you will see it.
You're talking claims against the state?
No, I think he's asking about the tort litigation fund.
Or if you have to go outside for special counsel, if you wouldn't be able to handle it within your office.
Correct. And that
470. I see it here. Litigation funds.
yes.
Okay, thank you. Thank you, Chair.
Okay, we're going to recess till Tuesday, January 24th, 10 a.m. Thank you.
Thank you.